So you've got a brilliant idea. You and your partners are ready to launch the next big Florida business. Profits are projected, roles are assigned, everyone's excited. But hold up, before you pop champagne, did anyone say the word shareholders agreement? I'm Santiago Cueto, a board-certified international attorney, and here's the truth. Friendships fade, businesses get messy, and lawsuits are expensive. A shareholder agreement isn't just a legal formality, it's your business prenup. And if you get it wrong, or worse, skip it altogether, you might just be handing over control of your company to someone's ex-spouse or worst enemy. Let's get real. Florida is one of the most business-friendly states in the country, but that doesn't mean you're protected from internal war. I've seen companies go from six-figure revenue to six-figure lawsuits overnight, and all because they didn't put things in writing from day one. A shareholder agreement does three things. It prevents drama, it keeps control in the right hands, and it protects your money and your sanity. And if you stay with me for the next few minutes, I'll give you the exact checklist of what to include so your business doesn't blow up from the inside out. All right, here are 6 crucial points that every Florida shareholder agreement must include if you want to keep the peace and protect your equity. Number 1, ownership structure. Spell out exactly who owns what. Is it 50-50, 70-30, 90-10? Put it in black and white. Florida courts love clarity. And number 2, roles and responsibilities. Are all shareholders directors? Are some passive investors? Define who calls the shots and who doesn't. Number 3, voting rights. Not all shares are created equal. Decide now. Who gets voting power and on what issues? Do major decisions require unanimous consent or just majority? Number 4, restrictions on share transfers. This one's huge. You don't want your partner's cousin buying into your business without your approval. Add right of first refusal clauses and clearly define how shares can be sold or transferred. Number 5, exit strategies and buy-sell provisions. What happens if someone dies, gets divorced, wants out? Florida courts will enforce what's in writing, but only if you've written it. And number 6, dividend policy. If profits are made, how are they distributed and when? Set expectations early to avoid resentment later. Here's where it gets Florida specific. In this state, if you don't have a shareholder agreement, the default rules kick in, and guess what? They may not favor founders. For example, without restrictions, any shareholder can force a corporate meeting, review your books, or even bring a derivative lawsuit if they feel oppressed. That's right, your own partner could sue the company from the inside. I've represented clients in Miami, Tampa, and Orlando who were blindsided when things went south. Why? Because they trusted a handshake instead of a signed agreement. Don't be that guy. Look, if you're building something worth protecting, a shareholder agreement is your blueprint for peace and power. You wouldn't build a house without architectural plans, right? Then why build a company without legal ones? And here's the best part. Get this right now, and you'll save yourself years of stress, court dates, and 5-figure legal bills later. So talk to your lawyer, sit down with your co-founders, have that awkward conversation, put it all in writing, and if you need help drafting it the right way, especially here in Florida, well, I'm a board-certified international business lawyer, and I've helped companies across the state get this right. If you found this helpful, do me a favor. Hit that like button, subscribe, and drop a comment below with your biggest business challenges. I'll answer every single one. And if you're ready to protect your company, let's build smart, let's build strong, and most importantly, let's build protected.